You are now tuned into the Black Law Students Association of Canada's YouTube. And without further ado, I will now cede the floor to Honorable Justices of the Diversity High Court of Canada, Justice Asha James and Justice Michael Fawcett.
Thank you. Good morning, everyone.
Justice James, would you like to be our president today? And I'll just sort of take a back seat.
But why, thank you. Sure, I'd be happy to do that. Right. So welcome the appellants and respondents to this round of the High Court. I'd ask that at the start that obviously you identify yourselves, give us your names, spelling, slowly so that we can make sure and get all of that down. And then also please just advise us as to how you will be splitting up your time. And so we would be ready to begin with the appellants whenever you're ready to start.
Good morning, Your Honorable Justices. I am before you today with my colleague representing the appellant Jamal Andrew Williams on the matter of Williams in Canada. If it pleases the court, my name is Turner, Turner, first initial C, and my co-counsel on this matter is uOttawa, Nwokocha, first initial T. I will be addressing our doctrine concerns today, and my co-counsel will be addressing our theory. The primary matter at issue today is the constitutionality of the Minister of Health's failure to collect disaggregated race-based data in light of the COVID-19 pandemic. The appellant, Mr. Williams, seeks a declaration that this failure is unconstitutional on the grounds that it violates Section 7 and Section 15 Charter rights and should not be saved by Section 1. In the judicial treatment of this case, two additional issues that I will be addressing today have come to light. The first being the imposition of a positive obligation pursuant to a charter infringement, and the second, the ramifications of the judiciary ruling on a matter which is so inherently political. Today, I intend to present to this court that the failure to collect data is an infringement on Mr. Williams' rights by addressing Section 7 with respect to right to the life, of liberty, and security of the person, with specific focus on life and security of the person, as well as discussing the principles of fundamental justice, namely arbitrariness, overbreadth, and gross disproportionality. I will also be providing an overview of the appellant's Section 15 infringement pertinent to the rights of equality. And finally, with respect to charter violations, I intend to address Section 1 as the reasonable limits clause. Before I conclude my submission, I would like to also address the adjacent concerns of positive obligations and the highly political nature of this issue. To contextualize the submission of the appellant, I would like to begin our formal submission by offering a brief overview of the pandemic history in Canada, which so closely parallels the current pandemic we are in.
Counsel, before you get to that, could we take care of one just housekeeping matter? How much time do you intend to take versus your colleague?
Thank you for the question, Mr. Justice. I intend to take about 23 minutes of our time, and my co-counsel has intended to take about 15 to 16 minutes of our time.
All right, and then I'm bad at math. How much time is that to reserve to reply?
That would be about 8 minutes for a reply, 7 or 8 minutes for a reply.
All right, thanks very much.
Thank you. My colleague, Mr. uOttawa, will first be addressing the importance of critical race theory in creating public health policies which accurately and altruistically promote equality. Secondly, he will discuss the theoretical importance of disaggregated data and the role of the Minister of Health, as well as the intersectionality of the public health sector. He will also conclude the appellant's submission and present the order sought by this claim. To begin, I would like to look to some recent Canadian history that I hope will serve to remind, inform, and contextualize the claims of the appellant. As I am sure this honorable court remembers, in 2009, Canada experienced its most recent pandemic before COVID-19, H1N1. H1N1 was colloquially deemed the swine flu and shared many similarities with COVID-19, both in the illness itself and in the fear and uncertainty that it invoked. While H1N1 has now been rendered part of the regular flu season, in 2009, it prompted a test of both our healthcare system and of the Canadian pandemic response protocols. Like COVID-19, H1N1 was a zoonotic disease which spread from humans to animals and when first detected, presented alarming and unknown effects for humans. Unlike H1N1, however, it is evident that COVID-19 has a higher infection rate and a higher case fatality rate, which is all the more reason to look carefully at the failures of the protocols during the H1N1 crisis. Using data from Ontario in the H1N1 crisis, the BMC Public Health Journal published a case control study that conclusively found, even where social determinants of health other than race were adjusted for, like socioeconomic status or education, adults who contracted the H1N1 virus were most likely to identify as East, Southeast Asian, South Asian, or Black. This means that regardless of any other social determinant of health, race has an undeniable impact on the outcomes of health and outcomes for Canadians.
Sorry, Council, can I ask you one more question? I missed this, but who was collecting that data with respect to H1N1?
Thank you for the question, Mr. Justice. That's the BMC Public Health Journal. And the study.
The federal government collect that race-based data during the H1N1 pandemic?
It wasn't through the government, it was through a private entity through the Public Health Journal system.
No, did the federal government collect that data?
The data that this journal is specifically referencing?
Yes.
No, I don't believe so. I believe this was actually privately collected.
All right. And if we talk about the COVID-19 pandemic, what data is the federal government collecting?
The federal government, with respect to overviewing the trends of social determinants of health, as far as we could determine, I found a public health study that briefly overviewed the survey of social determinants, but with respect to specific numbers, nothing is pertinent specifically and squarely on race with respect to data collection.
Right, but what data are they collecting? Do we know?
Currently, with respect to the social determinants of health, I would say that essentially nothing is being collected.
Do they collect gender?
I believe that you would see the collection of gender as part of the social determinants with respect to triaging patients. So I suppose, yes, you are correct, Mr. Justice, in assuming that information like gender is collected.
Do we collect address?
Correct, Mr. Justice, you are correct.
We are collecting the addresses.
Yes.
Anything else?
I suppose if we look to the triage, we would collect geography information, gender information, but I believe that would be the end of with respect to social determinants of health.
Anything with respect to socioeconomic status?
No, Mr. Justice.
Thank you.
Thank you for the question, Mr. Justice. May I continue?
Yes.
Yes.
This observation has never been more relevant than it is now, given that we find ourselves once again in a pandemic. A brief synopsis of the COVID-19 pandemic was published by Public Health Ontario in May of 2020. This synopsis made two very important findings. The first, that like H1N1, looking at general trends, that pandemic response and healthcare outcomes are still illustrating inequities in race. More simply, that H1N1 and COVID-19 are broadly demonstrating the same disproportionate statistics with respect to race. And secondly, that the collection of disaggregated race-based data is absolutely necessary to understand where the inequities exist and will be, quote, crucial to informing equitable response and preparedness in future phases of the pandemic, end quote. The appellant urges the court to carefully consider first, that the most recent experience in pandemic response during the H1N1 crisis undeniably failed racialized Canadians. And secondly, that the same problems are being identified by public health officials surveying general trends 10 years later without change. The policy to not collect disaggregated race-based data persists, even after explicit and public acknowledgement for its need. Disaggregated race-based data serves the function to better understand the inequities of race, which clearly exist in the Canadian pandemic response. This crucial information could be used to inform and develop medical best practice, but more imminently, to help create equitable and informed pandemic responses for future phases of COVID-19 and future health crises. While our friends will assert that the collection of this data cannot be considered crucial because we cannot know exactly what it will tell us, we strongly disagree. The collection of disaggregated race-based data will allow us to pinpoint, understand, and eradicate the racial inequalities in pandemic response that we know exist based on experiences like H1N1. I thank this honorable court for indulging me in providing this brief overview, and I will now turn my submission toward our charter considerations. Beginning with Section 7 and Section 15 infringements, the appellant submits that this matter invokes the Charter as the minister is both a public government official and she is granted her authority through the Department of Health Act. Where her discretion has been invoked to deny the collection of disaggregated data, we submit this constitutes a policy of inaction.
I understand your position to be that the minister has made a decision not to collect this data, but how do we know that?
Thank you for the question, Mr. Justice. What we're contending for the appellant is that the choice to not do it may not be explicit, but just as a policy to pursue the collection of this data would be a policy which is subject to charter scrutiny. The, I suppose, inexplicit choice not to do so is also a policy which is subject to charter scrutiny.
You agree with me that just mere inaction is not going to give rise to a claim under Section 7 of the Charter, right?
Respectfully, Mr. Justice, I disagree. Based on case precedent like Eldridge, we know that policy, which is subject to charter scrutiny, can take several different forms of applicable policy or legislature. And in this case, we actually constitute that inaction is the equivalent of a policy which should invoke charter scrutiny.
Do you have a case in which the court says that it will regulate government inaction under Section 7 of the Charter?
Thank you for the question, Mr. Justice. I believe it's RWSDU Dolphin that talks about the difference between government action and legislation, and that government actors and their actions should be subject to the scrutiny of the Charter.
Okay.
Does that sufficiently answer your question, Mr. Justice?
I'm still concerned. I have two concerns. The first is in trying to regulate government inaction. I'm concerned that there isn't precedent to do so. I understand the law as being that there are some past cases in which the Supreme Court hasn't foreclosed that route. But I'm not aware of a case that adopts it. And I have to admit, I'm not familiar with the Dolphin case, and I see that you've cited it, but without having read it or being taken to it, I can't say that it supports that proposition. And my second concern, which perhaps you could address now, is that I'm not sure where the line would be drawn if we create a legal rule that requires under which the court could require government to act. I appreciate that here it's just a narrow question. We want the government to collect disaggregated race-based data, but I mean, where's the limit if inaction is subject to legal regulation?
Thank you for the question, Mr. Justice. What I believe you're alluding to is the issue of the positive obligation. Am I correct?
Yeah.
Okay. If it's acceptable to the court, I do address the issue of positive obligations a little bit later in my submission, but to answer that now, I suppose, I'm not sure that there necessarily needs to be a line drawn in an action if the inaction violates Charter fundamental freedoms or guaranteed rights of the Charter. I respect that the court has concerns about how far that could be stretched in respect to a precedent, but I believe that if an inaction violates the guaranteed Charter rights, then I don't think there should be a line in applying that precedent.
So any time that my life, liberty, or security of the person is affected, and I believe that the government could do something to ameliorate that, then I have a justiciable Section 7 claim.
Thank you for the question again.
So if I'm, for example, being treated in the hospital and I feel like adequate resources are not being spent on my care, I can bring a Section 7 claim and ask the government to spend more money treating me.
Thank you for the question, Mr. Justice. If I may reorient the way that we think about this issue, it's with respect to the appellant submission, we've considered this as the failure to meet the necessary requirements as guaranteed by the Charter by this inaction, rather that this inaction is something that I am making an action against, but rather the government has failed me by virtue of an action.
Right. I think in my hypothetical, though, they'd also be failing me on your argument, right?
Thank you for the supplementary, Mr. Justice. With respect to the line that should be drawn, again, I have to reiterate that I don't think that in the case where the government is infringing on Section 7 or any right guaranteed by the Charter, that a precedent should be considered dangerous if it's protecting or upholding the Charter freedoms of an individual.
What do you think about this argument? Tell me if I'm right or wrong. The government's made a decision to collect certain information. You told me earlier that they're collecting gender and address, right? In making a decision to collect some information, but not others, the government has in fact made an affirmative choice not to collect race-based data.
Correct. Thank you for the question, Mr. Justice. That's exactly what the appellant submits.
And then so we're talking then about government action if it's an affirmative conscious choice. Is that right?
Yes, thank you, Mr. Justice. Correct.
All right. And so then if we have that, you have to show that not collecting that data is negatively impacting your client's life or security of the person.
Yes, thank you, Mr. Justice. Correct.
And how do we draw that link?
Where there is damage to the appellant, Mr. Jamal Andrew Williams.
Yeah, or anyone in a racialized community.
Correct. So what I hoped, thank you again for the question, Mr. Justice. I think that my point in alluding to the H1N1 crisis and the statistics that we see that are disproportionate with respect to racialized Canadians is that it's just simply not meeting the standard that's expected of non-racialized Canadians. And so I guess perhaps drawing the distinction that there is direct damage is the paradox of our position. But what we are suggesting is that the standard that's available to non-racialized Canadians is simply not being met. And that's where we are asking the court to find that we aren't asking for special treatment, but rather we're asking the court to find life and security of the person at risk, where the standard that is available to non-racialized Canadians is not being met.
How do you link that to the decision not to collect race-based data?
Thank you for the question, Mr. Justice. So what the causal link, I suppose, I guess is what we are talking about here now. The causal link between that relationship is that in order to create informed care and informed policies, we have to properly understand the inequities in race so that to create the proper protocols and in order for policymakers to be properly informed about the way that this social determinant of health affects the healthcare outcomes of racialized Canadians. So in order to be able to create informed care opportunities and informed policies, we have to have this data in order to be able to properly meet the standard that's required for racialized Canadians. Does that sufficiently answer your question, Mr. Justice?
Thank you.
Thank you. May I continue?
Yeah, please.
With respect to our Section 7 claims, that being the right to life and security of the person, I've just shared several of our points with Mr. Justice, so I'm just going to go ahead and skip ahead a little bit. So in the case at bar, Mr. Williams has had the choice of informed care revoked, and we must be certain that this is a choice that is available to non-racialized Canadians. Again, we are not asking this court to make special treatment for racialized Canadians, but instead to find that the standard of informed care and pandemic response is simply not being met for racialized Canadians. We contend that this infringement runs contrary to both life and security of the person, as well as 3 of the established principles of fundamental justice, those being arbitrariness, overbreadth, and gross disproportionality. And just before addressing these principles, I would like to draw the attention of the court directly to paragraph 45 of the respondent's factum to remind the court that where the respondent asserts that we are requesting the collection of all data pertinent to social determinants of health, they are mistaken. We are only looking for the collection which is specific to race. As for the principles of fundamental justice, arbitrariness is violated where the role of the minister is squarely based on the protection, prevention, and preservation of health for Canadians. As defined in the Department of Health Act, clearly her policy of inaction is having adverse effect by depriving individuals like Mr. Williams of informed care and equitable pandemic response, which reflects the diverse needs of Canadians. Overbreadth is violated where this policy, as has been alluded to at the lower courts, as motivated by a need to limit crucial resources, is outside the foundational purview of health meaning that if the objective of this policy is understood as limiting resources, it is overbroad to have such grave consequences on health. Finally, with respect to gross disproportionality, we know that from the 2013 Supreme Court case, Canada and Bedford, is where the effects of the deprivations are completely irrespective of the purpose or the policy of the legislation. The appellant again submits that if the purpose of this policy is to manage resources, it cannot reasonably be conceived as proportionate to health.
Can I ask you a question? When I expect your friends to say that one of the reasons they appreciate that collecting race-based data may have certain benefits, but collection is overweighed by the cost of doing so. And one of the costs is that collection of the data has the potential to exacerbate a tendency to racially profile Canadians. And originally I thought that was absurd, but then I was thinking about this a bit more last night, and I thought about what had happened in the States when the virus first came out, and the president was labeling the virus the China virus, right? And what we saw was an increase in, the racist tendencies of certain groups toward Asian Americans or Asians generally because of that label. Does collection of race-based data carry the same potential for harm?
Thank you for the question, Mr. Justice. And just before I answer your question, I would ask that the court invoke their discretion to extend my time about 10 minutes because I see we're about to run into the 5-minute mark, and I would like to properly answer this question for you.
Justice James?
Why don't we let you answer the question, and then we'll see where we are on time, and we'll make a decision as to whether or not we're required to provide the full 10 minutes or what time's appropriate.
Thank you, Madam Justice. With respect to the danger that this data presents in terms of confirming stereotypes and prejudicial minds or the possible misuse of the data, we absolutely agree that that's a pressing concern with respect to the collection of segregated race-based data. However, as we will argue today that this issue is squarely in the hands of the judiciary to rule on the matters regardless of political agendas which are outside the purview of this question, we will call on the legislature to make the appropriate safeguards to protect against things like violations of privacy and the misuse of this data.
I'm not talking about, wading into a political decision. What I'm saying is that under Section 7 and also under Section 15, the test is one of balance. Right? So whether or not something is arbitrary or whether it's disproportionate weighs the objective of the legislation against its effects. And ultimately, if you have a close call as to whether the benefits of collecting race-based data are outweighed by these costs, which you acknowledge is a pressing concern, shouldn't we leave that to the minister?
Thank you for the question, Mr. Justice. And again, from Canada and Bedford, I believe it's evident that the deprivation must be understood from the effects of the individual. So to your question, I would respond that absolutely, it is a pressing concern that this data might be misused, and that's absolutely a concern for individuals in respect to balancing. However, I would contend to that on behalf of the appellant that it will be more important to the appellants and to racialized Canadians that they receive informed care and that they aren't more likely to die in a pandemic because of under-inclusive and irrational policies than to have their data misused. Okay. Does that sufficiently answer your question, Mr. Justice?
Yeah, thank you.
Thank you. May I proceed?
Yes.
Please do.
Thank you. With respect to Section 15, that being the rights to equality, jurisprudence has broken this analysis into 3 claims, those being distinction, discrimination, and a possible third step of justification. This policy, on the face of it, does not create distinctions, which is the first step to establishing a Section 15 infringement. As our friends have reminded the court in their factum, however, case precedent from Corbier in Canada, a 1999 Supreme Court case, indicated that the identification of an embedded analogous grounds may be permitted at the discretion of the court where necessary to permit meaningful intergroup discrimination. The appellant submits that Mr. Williams, as a racialized Canadian, represents an embedded group within the context of Canadians. We acknowledge that this application, we acknowledge that the application of this precedent is done at the discretion of the court. However, we urge the court to make such a finding where Canada prides itself as a mosaic of identities, both racially and culturally. We cannot permit such important policies to exclude so many. The second step in establishing a Section 15 infringement is discrimination. The appellant acknowledges that this policy is universal, meaning on the face of it, it would be difficult to draw the inference of discrimination because it treats everyone the same. However, in a 1988 Supreme Court case, in Alberta, it was determined that under-inclusive universal policies may be considered discriminative by virtue of being irrationally under-inclusive. The appellant submits that where it should be known to the minister in the diligent completion of her duties that inequities have exist and do exist in the pandemic protocols, that a universal policy which is willfully blind to the inequities of race and health is irrationally under-inclusive and therefore discriminatory. It is here I would like to draw the attention of the court to paragraph 39 of the respondent's factum to highlight that we are certainly not claiming that the discrimination exists on the premise that Black Canadians have lower access to healthcare due to them being disadvantaged. Discrimination in the case at bar occurs by virtue of the policy being irrationally under-inclusive. As the final step in assessing a Section 15 infringement to look for a valid ameliorative purpose pursuant to Section 15 sub 2 of the Charter.
So, okay, I'm just going to ask you how much time you think you have remaining. Would an additional 5 minutes be sufficient to complete your argument?
Yes, thank you very much, Madam Justice.
Okay, so we'll provide her with additional 5 minutes to complete the argument.
Thank you. As 15 sub 2 is a burden which typically rests with our friends, I would just like to submit that where the policy is not reaching the standard expected for non-racialized Canadians, there can be no valid ameliorative purpose. With respect to Section 1, with prescription by law, pressing and substantial purpose, and proportionality, with prescription by law, we concede that where the minister has her authority from the Department of Health Act, this is certainly prescribed by law. To substantial and pressing and substantial, this we also concede, though we contend that fiscal considerations are dangerously close to outside the purview of health, which is the responsibility of the minister, we concede. Where we depart from our friends is over proportionality. Resources cannot and should not take precedence over health. These are disproportionate priorities. Professor Guy McPherson from the University of Arizona once said, quote, "Try counting your dollars while you hold your breath." And while Professor McPherson was speaking of the environment in this passage, I believe the analogy is still a very astute observation about societal priorities. Money, resources, or economy cannot be prioritized over the basic health of Canadians and the basic needs of Canadians. And pandemic response protocols should and must reflect the needs of all Canadians. Your Honorable Justices, neither infringement should be justified by Section 1 because even in a pandemic, our first priority must be to take care of the basic needs of all Canadians. And we contend this should include the right not to be more likely to die in a pandemic because of under-inclusive, inequitable policies of inaction. Before I conclude our doctrine submissions, Your Honors, Your Honorable Justices, I would like to direct your attention towards our factum at paragraph 76, discussing positive obligations placed on the government and on the question of separation of powers and the inherently political value of this issue at paragraph 82. By way of conclusion, I will hope that the court will permit me to introduce my co-counsel, Mr. Nkocha, who will consider the theoretical issues of the case at bar. If there are no further questions, please accept my thanks to the court.
Thank you.
Thank you. So we'll note that she's only taken an additional 2.5 minutes, and we will move on to your co-counsel, and the court's prepared to hear your submissions.
Thank you very much, Honorable Justices. Thank you, Ms. Turner. Good morning, Your Honorable Justices. I would like to start with an overview of the appellant's theory arguments. First, I'll outline why the failure of the minister to collect disaggregated race-based data facilitates a notion of colorblindness and is therefore discriminatory. Second, I will outline why the collection of aggregated race-based data is critical to highlight systemic racism rooted in the creation of policies, of public health policies. And finally, I'll outline why the minister's failure to collect disaggregated race-based data exacerbates inequality and prevents racialized people from receiving equitable care. I will now begin with the appellant's first theory argument. COVID-19 has had unparalleled impacts on Canadians, especially amongst individuals living in vulnerable communities. To understand the effects of COVID-19 has on vulnerable populations, this honorable court should order the minister to collect disaggregated race-based data for visible minorities, immigrants, Indigenous people, and other vulnerable populations.
Council, if we're not collecting the data, how do we know that? How do we know that it's having a disproportionate impact on vulnerable communities?
Thank you very much, Mr. Justice. We see from the reports that racialized people are suffering more from the COVID-19 pandemic. When we see areas that have suffered high numbers, we notice that they come from densely populated regions. For example, the Peel region is a region that is suffering a lot from the pandemic. And if you look at the demographics in the Peel region, for example, we see that racialized people are in the high end of the people that live there in the population. Thank you very much, Mr. Justice. Does that answer your question sufficiently?
Well, it does, but it answers my question, but it leads me to my next question, which is why isn't the collection of geographic location and address enough? Because I think, for those of us who are in Toronto, and I appreciate, I don't like Toronto is not the center of the world, but every now and then I click on the public health little map and it tells me where the cases are located. And one of the things that the city has been able to draw from that is the impact that the virus is having on racialized communities, and then it's able to take certain steps based on that information. So why do we need to go one step further?
Well, we need to go one step further because we need to, the mandate of the Minister of Health is to maintain and improve the healthcare of all Canadians. Now, Toronto is one example, but then if we look at racialized people in other parts outside of Toronto, we also see that racialized people are also suffering more than non-racialized people when it comes to the way in which this the pandemic has been handled by the federal government.
Right.
Does that sufficiently answer your question?
Why though we know that, right? The government knows that. Why do we need to go further and collect the race data?
Thank you very much, Mr. Justice. Because when we collect the data, like I will explain further in my my submission, when we collect the data, the Minister of Health is able to create policy that will better address and provide effective and efficient solutions to the way in which they've been handling the pandemic. For example, we have been, the federal government and also provincial governments, they have been working on the ball with, as new information are coming out, with redoing of models, right? So the numbers they're getting are changing as they go, and if they don't have the data to specifically speak to populations that are suffering more from the pandemic, they will not know how to adequately address that issue while they are dealing with the new numbers that are coming in and the models that they're looking at.
What about the argument that the collection of this data might lead to poor government decision making and politically motivated government decision?
I will speak to that in my
let me give you the example that I'm thinking of. One of the
Mr. Justice.
federal government has been doing, it has been targeting vaccination efforts toward the northern communities, right? And I understand why they are doing that, but there is one position out there that those efforts are actually contrary to science and not in the best interest of managing the pandemic, but rather politically motivated for reasons that are understandable. But what do you say that collection of this data might actually hinder the federal government's efforts to fight the virus?
Thank you very much, Mr. Justice. I somewhat agree with you, but what you've alluded there is the presence of systemic racism in the system that we are all coexisting in here, right? So what we're doing here now, like your point is valid, but at the same time, we cannot stop the push for equitable care in terms of when we speak about racialized people. And also, we could also then fight the systemic racism that is happening within that very system. We could criticize the system, but we could also push the system to do what is right, Mr. Justice.
Okay.
And so what do you say to the argument that there are better data points or better points of analysis other than race to determine what is appropriate kind of health policies in practice? That
Thank you very much.
while
Madam
race
Justice.
may be one factor, it's not as important a factor as you're making it out to be. And there are other factors that could be collected that would be more helpful in guiding policy.
Thank you very much, Your Honor. Respectfully, I disagree with that, with the notion that race is not an important factor or not as important. Madam Justice, we live in a society where from the moment of first interaction, the way in which you're treated, especially in the healthcare system, is determined by what you look like. If you're a white person, you're afforded more care, afforded more respect than the non-white individual. So now when we bring that down into the way in which policy is created and drafted, we see that racialized people are not taken into account in the right way. I believe Professor Kwame in a study, or sorry, in an article he published, says the title of the article is, if you're not counted for the pandemic, then you cannot count on the pandemic response. You understand? Go ahead, then, Madam Justice.
Yeah. So then, isn't the issue though that Justice Fawcett asked about this when he asked, like, where do you go down this slope, right? So then is the issue that it's not just about the collection of race-based data in terms of COVID response, right? But essentially what you're looking for is the collection of race-based data in terms of all health responses, because you're not just saying in terms of the pandemic, we should stop it here. Like, really, to address the issues that you're raising is you want race-based data collected in terms of all health services being provided.
Thank you very much for your question, Madam Justice. The point you've made there could be part of the ripple effect of the change that we're asking for the order we're asking for. At the moment, we're squarely focused on the question in front of us, which is collecting aggregated data to help address the inequities that racialized people are facing. Now, if that change comes and we see a ripple effect into other sectors, then it is our position that collecting that data to help adequately address the inequities racialized people face when it comes to healthcare in Canada should be a good thing. I would like to remind this honorable court, like I will reinstate and reinforce as I go forward, that the mandate of the Minister of Health is to maintain and improve the healthcare of all Canadians. And by not doing so, in failing to collect disaggregated race-based data in the response to COVID-19 pandemic, is failing to maintain and uphold the mandate of their office. Does that sufficiently answer your question, Madam Justice?
But your friends say that the decision not to collect the data is in furtherance of that objective. Right? It is in furtherance of maintaining and improving the health of Canadians. That's why they're. And so whose call is that? Why should that be the court's call as opposed to the minister's?
Well, thank you very much for that question, Mr. Justice, and I will allude to that in later on in my submissions as well, if that is okay.
Sure.
Thank you very much. So heading back into my submission. Historically, health sciences have always reflected the racial notions pervaded in society. And in that, it is clear that the intellectual contributions of people of color are rarely included, and hence the reason why we see that gap when it comes to the drafting and creation of policy. The respondent in paragraph 62 of their factums agrees with my aforementioned point. They accept that discrimination is systemic, it is endemic, and that racial hierarchies prevail in many governmental institutions, including healthcare. Now, where the respondent will state that the right course of action is to not collect race-based, aggregated race-based data, is to go against their statement, which is that discrimination is systemic and endemic, and that racial hierarchies exist and prevail in many governmental healthcare systems, including healthcare systems. The healthcare system. The fact that the minister did not see the importance of collecting disaggregated race-based data on the effects of COVID-19 on particular populations illustrates the lack of intellectual contributions of racialized and indigenous people in the creation and drafting of public health policies, thereby maintaining and allowing the very systemic, endemic, and racial hierarchies to continue to prevail in governmental institutions. It is Appellants' position that a critical race theory lens needs to be applied when creating public health policies. It allows for key actors to identify racial biases in drafting of policies and provides an opportunity in which the professional perspective of marginalized individuals is incorporated in the creation of public health policies that better serves the interests of racialized communities and non-racialized communities. The first page of the important resources that should be disaggregated race-based data, which will allow the minister to make the most educated decision on how to properly address the healthcare needs of all Canadians.
Council, do you mind if I ask you one more question? This has been something that I have not figured out. How do you propose we do this? How do you want to collect this data?
We collect this data by looking at every patient that comes in, either for testing, either that needs care when it comes to their health. So
okay. You want me to create a rule that says healthcare providers. So when you're in the hospital doing triage, you're at a private clinic taking a COVID test, you're vaccinating someone. You want me to say to them, you want that person to say, what is your race?
Precisely.
And you also acknowledge that there is systematic racism inherent in the Canadian medical system.
That is correct.
That racialized individuals receive worse care than non-racialized Canadians.
The numbers and the reports speaks to that, Mr. Justice.
And so you want to trust the institution, which you argue is inherently racist, with collecting this data and then acting on it in providing care to Canadians who are affected by the virus.
Yes, Mr. Justice, and I'll explain that.
How does that make any sense?
Well, thank you very much, Mr. Justice. Like I stated earlier, we can criticize the system and also ask for the system to make positive change. We know that the system that there's systemic racism that breeds and lives within various institutions that we saw. The justice system itself, some people will argue, is
but for that reason,
enables systemic racism of some sort.
For that very reason, the justice system does not treat people differently based on race. It has made a conscious decision. We are not going to ask jurors who are put on a jury roll, what is your race? Or we're not going to ask a defendant when he walks into a courtroom, what is your race? Because it's completely irrelevant to the way that they're treated by the justice system.
Well, Mr. Justice, thank you very much for that point. And this is what we are calling for. We need to apply a critical race theory lens when we are accessing justice. That is the argument we're making here. In my part here, we need to apply the critical race theory objective lens when accessing and giving out justice.
Okay.
Does that sufficiently answer your question, Mr. Justice?
Yeah, I have your response.
Thank you very much.
So
further,
I think I have a question flowing from that and trying to understand, right? I understand your position about the need for race-based data. I understand that. I think my concern is, and your co-counsel addressed this in her submissions, right? That there are a lot of other factors that go into determining the inequities and treatments that people receive within the healthcare, right? Some of those are socioeconomic, some of those are geographic, right? So while we will have geographical information because we'll have addresses, we'll have age, and gender, that the argument that the socioeconomic factors are as big, play as big a role as race in determining kind of what policy should be put out there and how certain vulnerable groups are being adversely affected by the virus, right? So, well, I guess my question is, I don't know that just collecting race is enough to get you what you want to get. And so if that's the case, then why should we do it when you've acknowledged that there are kind of policy reasons under Section 1 that would come into play, right? So if at the end of the day, just collecting the data you want is not going to be sufficient to actually produce the outcomes that you're looking for, why should we do it?
Well, we believe that collecting the data is an important step in providing equitable access to racialized people in terms of healthcare services. Now, my response, and again, thank you very much, Madam Justice, for your question. My response to that will be, when looking at how rich a person is or what socioeconomic bracket they fall under, a Black person who is worth $50 million, right, could also be let down when it comes to equitable access to healthcare. So looking at their economic stance or their economic value is one way, but it doesn't really speak to what race, how race will address the issue. Yes, we can look at their geographic region. Yes, we can look at their social status, but until we look at the impact race and racism pertaining to COVID-19 and the way in which it intersects, then we will not be able to fully and efficiently address this issue. Can I move on, Madam Justice?
Yes, thank you.
Thank you very much. Further, as I was stating earlier, the respondents in paragraph 63 of their factum stated that this honorable court should defer to the legislature in situations of historical injustice. Your Honorable Justice, the notion of passing the buck and responsibility to another body should not be one this honorable court should accept. This court, the Diversity High Court of Canada, does have the requisite exercise to overturn this decision. Disaggregated data is a priority because the lives of vulnerable Canadians are at stake. Providing economic relief to Canadians that qualified did not stop the spread of COVID-19. Actually, we saw a spike of positive cases in areas that are densely populated after the government ended the Canada Emergency Response Benefit. Providing financial assistance to Canadians when they needed it the most was important, but having the proper tools and the essential data to address the disparities racialized people face when accessing healthcare services in Canada is arguably as important as economic relief, or even more important. The argument that by collecting disaggregated race-based data would ignore the economic and health priorities that each province should focus on is a flawed one. It is evident that race is a social construct with no biological or sufficient research to state otherwise. Simply put, the idea of race and race as categories, if it would please the court, if we could extend our time for 2.5 more minutes.
Yeah, we will provide you with the additional 2.5 more minutes.
Thank you, Madam Justice. Simply put, the idea of race and races are categories and hierarchies that society invents, manipulates, or retires when convenient. The respondents in paragraph 64 of their factum state that they oppose the collection of disaggregated race-based data due to the prejudicial effects on racialized groups. This, in essence, speaks to a colorblind approach. The idea that if the minister collects disaggregated race-based data, racialized people will suffer, when a colorblind approach will better serve the racialized group, is one in which the appellants finds lacking and uncompelling. The failure to collect disaggregated race-based data does not facilitate equality. The lack of race-based data does not demonstrate equality, but rather facilitates the notion of colorblindness. Institutions, as we know, that incorporate a colorblind approach do not adequately address inequities of race, especially when we talk about it in the context of healthcare. Claiming to adopt a colorblind approach has resulted in increased health inequities with and poor health outcomes for Black and Indigenous and racialized communities. The colorblind approach enables one to ignore racial differences in order to recognize an individual's humanity. It is the appellant's position that the failure to collect disaggregated race-based data is to ignore racialized people and the negative impact which has imposed on racialized communities. I will quickly speak on the public health sector. The public health sector works with multiple intersecting individuals, yet the framework of intersectionality is rarely applied into their profession. Intersectionality addresses a person's social and political identities that shapes their differences among the same groups. In conclusion, this appellant submits that the failure to collect disaggregated race-based data rises to the necessary endangerment required to engage the right to life and security of person pursuant to a Section 7 infringement. Further, based on case precedent, we know that it is within the realm of possibility that a positive obligation could be imposed pursuant to a charter infringement. As well, where the request that the time we made to this court is the only rule on the matter at hand not to create or enforce law, we contend that this matter is squarely appropriate in the hands of the judiciary. With respect of this claim, the appellant takes a declaration from this court, which finds the minister's failure to collect disaggregated data unconstitutional. Subject to further questions, these are the submissions of the appellants. Thank you, Your Honorable Justices.
Thank you, counsel.
Thank you. We're happy to move on and hear from the respondents now.
Absolutely, Justice. Before I start, you may have noticed that I've been coming in and out. My internet is very unstable at home, so I am calling in from my phone. If this drops, I will try to figure out a different way to join the Zoom meeting, but if I do cut out for a brief moment, just please flag me down and tell me where I lost you, and I'd be happy to come back and address your questions. Good afternoon, Justice James. Good morning, rather, Justice James and Justice Fawcett. My name is Philip Byun, B-Y-U-N. And along with my co-counsel, Nicole Beausoleil, we represent the respondent, the Minister of Health, who throughout our submissions, I will refer to as the Minister. During my brief submissions today, I would first like to address some of the concerns raised by our friends with regard to the non-collection of race-based data and its effect on racism in our society.
Counsel, I know you have your overview. I just wanted to ask two questions before we get into it. One is the housekeeping on the timing. What are you thinking in terms of breaking this up with your colleague?
Sure. We plan to divide our time equally today, 22 minutes each, Justice Fawcett.
Okay, thanks very much. My next question, and this is it's just been bugging me. Why are you not collecting this data?
Justice, that's an excellent question. And you may wonder why. And I've been thinking about the same thing as well. Why is the minister not collecting this data if it's going to be relevant to coming up with a more informed decision? And I think the key is right there. It may be relevant, but it's not material, Justice Fawcett. There is a difference between relevance and material. Any information that can help to address the COVID-19 pandemic will be relevant, but in this case, the race-based data, as you alluded to in your questions earlier, is not material in a sense that it doesn't lead to the best outcome. It doesn't lead to the best approach to combating and stopping the spread of COVID-19.
Okay, I'll let you get back to your overview. I just want to ask one follow-up. You agree with me that the minister made a conscious decision not to collect this data?
Yes, we agree with that comment, sir.
Okay, and then so because it's an affirmative decision, then this is a case of action, not inaction.
We do not disagree. We do not agree with that portion, Justice.
Well, she decided to collect some information, but not others. How's that not? I don't understand how that's inaction.
It's inaction in a sense that the minister was not obligated to collect any data, any race-based data. she came up with a decision that is based on geographical and location data that is more relevant and more material to this to combating COVID-19.
Well, I understand that point, and I'll let you come back to that. But the question I'm asking is this distinction between action and inaction, and a conscious decision, which you agree that the minister made, seems to me to be the very definition of government action.
There can be many varieties of forms of government action, Justice Fawcett, but just because you leave something out doesn't necessarily mean that it was in action. I'm not sure if that.
Well, I think I have your point, but I'm not sure I'm persuaded on that.
Perhaps I could persuade you during my submissions, Justice Fawcett.
All right.
So just to break down give you a little roadmap of how our conversation will go today. I will, as I mentioned, I will address some of the concerns first. I will be talking about the Section 7 charter arguments, which will be followed by my co-counsel's Section 15 and Section 1 analysis. And my co-counsel will end by talking about the jurisdiction of this court in adjudicating this matter at bar. With this in mind, we ask this court to confirm the Supreme Court of Canada's decision and find that the minister's decision is not unconstitutional. To expand on my overview statement, Justice, the COVID-19 pandemic has caused some major irreparable damages in Canada and throughout the globe. As of today, there has been 105 million cases worldwide, and the pandemic has taken 20,609 Canadian lives, which is a number that has more than doubled since September. Despite these numbers, the harm that the coronavirus has caused extends beyond the realm of numbers and statistics. It's a vicious, highly contagious virus that attacks without regard of the color of the skin. It has destroyed thousands of Canadian lives and brought chaos into our society. And that's why the minister understands what the appellant, Mr. Williams, is going through. The minister understands that he fears contracting COVID-19 and that his family may contract COVID-19. At the same time, I would like to remind the court that Canada has been a leader during the pandemic in terms of containing the spread of virus within our borders. And once again, going back, the minister has relied on evidence-based policies that take into account the geographical and location data to stop the spread of COVID-19. And because we know that it spreads between proximity between people.
Well, counsel, how can you say that the minister is relying on kind of evidence-based information to create policies when they're not collecting all of the necessary evidence, right? That is your friend's position, is that, yeah, the evidence that you're collecting is not sufficient to meet the needs of all Canadians. And so how do you respond to that in saying that, you know, because really what you're saying is we're doing a good job. We're collecting the information that's needed based on the evidence to create these policies. And what your friends are saying is the information that you're collecting is not sufficient. There's a gap.
Justice, I believe I attempted to address this earlier in my answer to Justice Fawcett, in a sense that what the appellant is asking us to do, we concede that we're collecting race-based data may be relevant, but it is not material. We know that COVID-19 virus spreads through proximity between people, and it attacks people without regard for the color of their skin. And therefore, relying on the scientific fact that we need to look at hotspots and neighborhoods, like Justice Fawcett mentioned in his question earlier, that's more relevant and material to addressing this question. It's not the fact that Black people are Black that they're more prone to contracting COVID-19. It's because of the underlying socioeconomic factors. This is not about race.
Okay, well, so that's one point of it. That's one part of the contraction of the disease. But what about the other part in terms of treatment outcomes when you're in the hospital, right? So there may be increased comorbidities for people in, African Canadians, Indigenous people, right? So they may have higher comorbidities that create worse outcomes for them in terms of how the disease affects their physical health. And so if we don't have that collection of race-based data, I understand your point in terms of we know how it's spread. It doesn't say, well, we're just going to jump from Black person to Black person or from Indigenous person to Indigenous person. That's not how the disease works. But their race does play a factor in how they get treatment for the disease. And shouldn't that be something that we consider in how we're creating policy and in responding to the COVID pandemic? It's not just about contraction, it's also about kind of treatment.
That's precisely the reason why we're not collecting race-based data, Justice James, because we know that there's history of institutional racism in the medical field. To answer your hypothetical question earlier, imagine that we start collecting race-based data, and then it shows, as it does in the United States and the United Kingdom, that Black people are more likely to contract COVID-19. What happens when a Black person goes to a hospital to an emergency because he has a chest pain? Well, what we fear is that we have seen medical racism in a sense that we fear that if this person comes to the hospital, that person, because the fact that he is Black, will be painted with a broad stroke that because he's Black, he is likely to have COVID-19. But that may not be the case. He may be having some acute pneumonia or any other types of symptoms that are similar to COVID-19. But because of the racial stereotypes that we have seen in the medical field, he may be misdiagnosed as having COVID-19, which is even worse.
Counsel, can I ask you, this is the problem I have with that argument. Why does the minister get to make a decision that it's worse for the racialized individual to provide their race? And why, quite frankly, would we get to make that decision? Why shouldn't that be decision being made by the racialized individual when they go in to get treatment and they are asked what is their race? Then it's up to them whether or not they answer the question. Why don't we leave it up to them whether it's in their best interest to provide the information?
So to understand your question, Justice, are you asking why do we not leave it up to the people to decide what's best for them instead of the minister?
Yeah, that's exactly right. You're telling me that you've made a decision, you understand that this information is relevant, but the minister has decided that it is not in the interest of racialized or Black Canadians to provide race-based data to the government for the reason that they might receive some lesser standard of care or experience systematic racism in doing so. And I don't understand why the minister is making that decision, and I don't understand why we would make that decision. Why isn't it being left up to the individuals who are actually going to be affected?
Justice, I will answer that question by thinking about why we collect data in the first place. The reason why we collect data is to make sound evidence-based information. If it's up to the people to decide whether they want to submit their race-relevant data, what possible good outcome can come out of this? For example, a lot of people who, for example, I'm from an Asian background, but I might not identify as Asian. I'm just giving a hypothetical example here. That's going to distort the data and lead to outcomes that that might not even be relevant and useful to make policies to help these people.
But now you're saying not only should we decide that it's better for them to not provide the information, but we should also assign the race to them and disregard self-identification.
No, that's precisely the reason why we're not collecting race-based data. It's because we want to avoid all of this all of this inconsistencies that may arise from collecting race-based data. So I think it might be actually helping understand your question. It might be aiding your question about that aspect, Justice Fawcett.
Maybe, can we do this? Let's just go back to the legal doctrine and in particular Section 7. So I just want to understand how your argument fits in. So the first thing you need is state action. We had that conversation. We disagree whether there's state action here. The second thing is the state action has to affect someone's life, liberty, or security of the person, right?
Mm-hmm.
And you agree with me that racialized individuals are disproportionately affected by the virus, correct?
We don't know that for sure in Canada because we don't have the data, but
well, we have
I would tend to agree that may be the case looking at the evidence from other countries, yes.
But also the federal government has been encouraging the provinces and the municipalities to collect race-based data because they haven't been doing it. And the evidence the data that's being collected at the local level is telling us that the virus disproportionately affects racialized individuals.
Yes, I would agree with that statement.
All right. And then you also said earlier that collection of race-based data is relevant in the sense that we could make decisions, medical decisions, that attempt to ameliorate the disproportionate impact on racialized individuals. For example, we could direct resources to those communities, increase testing centers, increase vaccinations, et cetera. So there is a causal link between the two, right?
There's a causal link in a sense that it's linked to the socioeconomic factors, not race.
But I thought we do you agree with the proposition that if we had race-based data, we could make better decisions to affect to improve our response in racialized communities?
Only to the extent that the underlying socioeconomic factors are the reason why marginalized communities are being more affected, and not because of the fact that they are racialized minority groups.
Then I don't understand your concession that the data is relevant.
I merely suggested that it may be relevant, but it's not material to our decision-making process.
Well, relevant. Sorry, Justice James.
No, go ahead.
Relevant implies a causal, like a logical connection between the data and what we might be able to do with it, right?
Yes.
Right. Okay. So there's some link.
Absolutely, there may be some link, but it doesn't lead to the best approach. The best approach is to stop the spread of COVID-19 using the geographical and location data.
But with respect, you don't actually know that, right? Because you're not collecting the data. So you don't know whether or not it's material because you don't have it, and you haven't been able to analyze it and say whether or not it is actually a material factor. You've just determined, pretty much what the government has said is, we don't want to do this, it's too expensive. And we've determined that it may not be in the best interest of racialized people because, you've given us a hypothetical. They may go to the hospital and have some other type of ailment, and people will say, well, there's a higher incidence of COVID in Black individuals, so it must be COVID. And they won't do kind of, their proper testing and determinations. But you don't actually know whether or not the race-based evidence is material because you haven't collected it, you haven't analyzed it. You don't know how it actually affects the outcome and may actually assist in policy.
To address that question, I go back to the institutional medical racism in our country. Justice, perhaps this anecdote will make sense to you. You may recall the name Joyce Echaquan. She's not a Black person, but she's an Indigenous person who died in a hospital in Quebec a few months ago. Because the fact that she is Indigenous, the medical staff over there have routinely ignored her cry for help, consistently misdiagnosed her level of pain, and even made derogatory comments towards her because she is Indigenous. And we believe this isn't just one example. There are anecdotes and studies that prove the existence of medical racism in our society, and that Black people and Indigenous people, other racialized minority groups, are consistently being misdiagnosed by the medical staff. What we need is race-sensitive training before we can introduce the race-based data that may be used to stereotype and further discriminate marginalized communities.
But what I don't understand is how the collection of data has anything to do with that. She was mistreated horribly because she was Indigenous, and it had nothing to do with whether or not she checked the Indigenous box on a question that she was asked by the government. And that's the same thing with Black individuals who experience systematic racism in the medical system. It has nothing to do with the question that they're asked at triage, right? And so I don't understand the link that you're drawing between if we collect this data, then we will exacerbate the problem. It seems to me those two things are completely unrelated.
They are related in a sense that race-based data is both linked to prevention. It may be, I misspoke. The geographical data is is linked to more prevention and treatment and targeted advertisement towards places that are being affected by COVID-19. Justice Fawcett, I'm not sure if I completely understood your question. I would like to ask you if you could repeat your question, please.
Yeah, no, I understood your response to be, what I understand your response to the argument that's put against you is, look, we have state action. Yes, I appreciate that there's a causal link, but ultimately the decision falls to the minister. And so long as that decision is made in accordance with the fundamental principles of justice, then the court would defer to her decision. And you appreciate that there are some benefits associated with collecting information, but those benefits are outweighed by the cost of doing so. And the principal cost that you've identified is that someone might experience there might be a greater prevalence of racism faced by a racialized individual because they have answered a question that says, I am Black, or I am Asian, or I am Indigenous. And what I don't understand is the link between answering that question and the treatment that someone is going to receive in the Canadian healthcare system.
Because even before coming, I'm just going to use an example. Even before coming to a patient, a doctor or nurse may read the patient information, see that he or she may be Black, and say that, okay, Black person, respiratory problems. They're going in with a prejudiced mind that this is likely to be COVID-19.
I see. Okay.
Justice, if you would like, I realize that I have about just less than 3 minutes. I do not wish to go all the way into my Section 7 analysis because I don't have the time, but I would like to address just one point that there is no positive obligation on the minister. If you have any questions, I would welcome those questions, of course. What the appellant here is asking us to do, or what this appellant is asking this court to do, is to reverse the Section 7 jurisprudence in Canada and the sound reasoning of the Canadian courts. They address some of the cases like Gosselin and Bedford, and this comes back to your question, Justice Fawcett, that my apologies, my phone is dying almost. Those cases dealt with government actions that deprived the Canadian individuals' rights. Here, that's not the case. While we agree that the Canadian courts have left the door open to recognizing positive rights under Section 7, for example, in Gosselin, we argued that during the uncertain times of COVID-19 pandemic and the chaos that it has brought into our society, what the Canadian people need more now than ever is for the government to provide more consistency, certainty, and predictability. Committing the government to provide positive obligation and recognize under Section 7 will fundamentally change and challenge the ability of the government to carry out its duties and responsibilities as a democratic institution. And there's a reason why the courts have refused to recognize positive right under Section 7, and that is because when it comes to policy-related questions, the deference to the legislature makes more sense. The legislature is more equipped to handle policy questions than the courts. Now, I don't wish to jump a little bit more into that because my co-counsel will argue that in her theoretical argument. But my point here is that, of course, the government wants to provide every single social and economical resources to the Canadian people. But the reason why the government exists in the first place is because we need an institution that can prioritize the taxpayers' money and figure out how it should be spent the best way because of the issues of resource allocation. Simply put, we don't have infinite amount of resources and money to address every single Canadian's needs. Justice, I realize that I may have more time than I realized. With maybe 2 or 3 more minutes, I can get into the engagement of Section 7 rights, if that's permitted.
Please go ahead.
Thank you. In this case, so my second part about Section 7 is that there is no engagement of Section 7 rights in this case. The appellant's Section 7 right is not engaged here because the minister's decision does not increase his risk of death. And this reasoning is coming from Chauli, where the Supreme Court determined that the Quebec government's ban on private health insurance was unconstitutional because it increased the risk of death. But the ban wasn't unconstitutional because it directly increased the risk of death, but because it prohibited reasonable, timely access to healthcare services. Now, this simply isn't true at this case at bar. The minister's decision not to collect race-based data does not impose any restrictions or prohibitions on Mr. Williams. There is no unreasonable, timely access to life-saving health services. There is 192 COVID-19 testing centers in GTA, Greater Toronto Area, 27 in the Greater Ottawa area, and 416 in other centers throughout Ontario alone. If a person contracts COVID-19, as I mentioned earlier, you can go to the nearby hospital and be selected as a top priority during triage and receive treatments before other patients. And if this person needs to stay longer in the intensive care unit, the cost is covered by OHIP, the Ontario Health Insurance Plan. These are examples that show that the minister and the federal government is capable of helping Black Canadians without having to collect race-based data. There is reasonable, timely access to the life-saving services, and therefore the minister's decision does not increase the appellant's risk of death. Justices, I realize that I have now run out of my time. Subject to further questions, those are the extent of my submissions on Section 7.
Thank you. I don't have any further questions.
Thank you, Justice James.
So we'll be happy to hear from your co-counsel now.
Good morning, Justice James and Justice Fawcett. My name is
Oh no.
Ausoleil.
Can you try that again? You broke up a little bit.
Sorry.
Yeah. Can you spell that
Oh.
again? You broke up a little bit.
Yes. BEAUSLEL.
Okay.
Okay. I just got a notification my internet connection is unstable, so I hope you can still hear me.
We can hear you.
Can you still hear? Okay, great. As my colleague mentioned, my submissions today will outline the government's Section 15 argument, as well as our last theoretical argument that deference to the legislature in this matter is appropriate. To begin, I invite the justices to look at paragraphs 15 to 18 of our factum, as it outlines the analytical framework that we use for this Section 15 analysis. For the step of the we argue there's no distinction on an enumerated or analogous ground. The distinction advanced in the appellant's argument is flawed. It fails to prove that Black Canadians receive differential treatment and are not given equal access to resources needed to combat COVID-19. First, the minister has been consistent with all Canadians on how to protect themselves and their families from the virus. All Canadians have been told about the benefits of wearing a mask in public, social distancing, and of course, staying home. All Canadians will have access to the vaccine once it's readily available. Second, all Canadians who met the requisite criteria were given the ability to claim the Canada Emergency Response Benefit, or the CERB, to combat the pandemic's financial difficulties. The Canadian response has been better than most countries in supporting its citizens financially during this challenging time. For example, if we look to our friends south of the border, there's still debate in terms of how much money certain citizens will get, how much the next stimulus check will be. Whereas in Canada, we already solved that problem months ago.
Counsel, do you disagree with the proposition that Canada's response to the pandemic would be improved by targeting certain geographic areas that are hit hardest by the virus? You talked about mask wearing and social distancing and washing hands, but there's a lot more to the pandemic response. It's the increase in testing centers, random testing, private vaccination clinics, vaccinations, educational outreach, et cetera, et cetera. If we know where the virus is hitting the hardest, we can direct resources to those areas, correct?
Well, correct. There is information and statistics rather, and the citizens who are most at high risk for severe COVID-19 outcomes. And the government's resources have gone to sending PPE and the required resources to those communities specifically. And those specific Canadians are at the top of the list in terms of getting the vaccine once it is readily available. And
Right.
in terms of geographical, I'm sorry?
So we agree that geography is relevant.
We agree geography is relevant.
And I think that your colleague also acknowledged that socioeconomic status is relevant.
Yes, we agree that socioeconomic status is relevant.
And there is a link between race and geography and race and social economic status, correct?
Correct.
And so there is clearly a link then between race and the response. All three of those things go hand in.
Absolutely. But our data specifically is focusing on the communities as a whole that are high risk. So whether medical conditions and to, specific for socioeconomic outcomes, we are targeting certain like essential services, our postal workers. We understand those Canadians are at high risk. Canadians that are potentially in poorer housing can adequately distance themselves from their neighbors. So those are the Canadians that our resources are focused on as those Canadians are at high risk. If the Black Canadians may, of course, be in those groups, and those Black Canadians are getting our additional resources. I hope that
right, but they're not.
something.
It's not a perfect. Actually, Council, we're getting like about 90% of what you're saying, but your internet is a little bit sticky at times. One thing that can help is if maybe the non-speaking participants could just turn off their videos, and sometimes that'll help with your bandwidth. And let's see if this improves it.
I can actually put on a hotspot. If you just give me 1 second, I might cut
Okay.
out. That might be helpful. Can you hear me now?
Yes.
Okay, great. I have my hotspot on, so it should be working now. I apologize, Justice. Where did we leave off?
You were saying that because we are already targeting resources on the basis of geography and socioeconomic status, that we don't need to track race data.
Well, we argue that there is already pre-COVID, there is data that we have that is specific to Black Canadians. For example, pre-pandemic surveys show that there are many Black Canadians in poor housing situations that, of course, would make combating COVID-19 more challenging. And we do have the experts who are addressing those issues now. So the race-based data in the context of COVID is not necessary because the government has initiatives in place to combat some of the racial disparities that the appellant is concerned about. And additionally, if we look to, for example, our friends south of the border, they have been collecting race-based data for years. And to what end? So we argue that, yes, the race-based data, we concede, could help the government understand where COVID is more prevalent, but it does not necessarily lead to the necessary steps to mitigate these racial disparities. But this government has already taken those steps pre-pandemic to mitigate some of these racial disparities. So Justice Fawcett, I hope that answers your question, and I hope I didn't cut out again.
No, actually your internet's much better now.
Okay, fantastic, thank you. So the minister has found, as I mentioned, that there are specific Canadians at high risk for severe COVID-19 outcomes. Those Canadians with lung disease, cancer, and hypertension, but Black Canadians are not specifically at risk, but thus not warranting any additional resources from the federal government to combat COVID-19 than other Canadians. The government's resources need to be used to expedite vaccine and PPE rollout to these high-risk communities. And however, currently, there are additional resources available to Black Canadians outside of the federal government's jurisdiction if they need more assistance to protect themselves from the virus. For example, Toronto's municipal government is offering isolation centers for people currently living in crowded housing, as I mentioned, and cannot correctly distance themselves from their neighbors, or if they're working in essential services and are concerned about spreading the virus to their household. As well, community organizations like TAIBU, T-A-I-B-U, are directly supporting Black communities by providing primary health care, doctor's appointments, and other related services to the Black community. In fact, just this week, Toronto's Mayor John Tory announced that TAIBU and other community organizations are developing a Black community COVID response plan. And in this plan, the mandate is to increase vaccine trust in the Black community, and as well as develop some other health and safety initiatives.
I'm not quite sure I understand how this helps you.
That's what I was I was going to ask the same question, because it appears what you're saying now is all of this is relevant, like this, all of this is important, but we don't have to do it because somebody else is doing it, right? We've passed the buck.
Well, it's not necessarily about passing the buck. I'm just saying that there are organizations in place that are mitigating some of these racial disparities that the appellant is concerned about. But these decisions have been made without, of course, collecting any race-based data. So the point, the crux of the appellant—
That's true, because they are collecting race-based data at the provincial and municipal level. Toronto Public Health collects race-based data. And now they're acting on it, it sounds like, and they're acting on it in a way that you view as positive, which I think then ultimately hurts your position, which is why isn't the federal government doing the same thing?
Well, the municipal government, like Toronto, for example, is not necessarily responding to race-based data specifically. They're responding to information regarding socioeconomic status and the fact that many essential services are at risk. Those living in poor housing communities or poor housing is at risk, not specifically Black Canadians. Now, whereas TAIBU
race-based data, right?
I'm sorry.
Toronto collects race-based data.
Toronto does collect race-based data, but what I'm trying to argue is that
they do so because the federal government encouraged them to do so.
That is true.
Right. And the federal government encouraged them because they thought it was important.
Well, yes, the federal, we can see that it is important to understand where COVID is spreading. But what I'm saying is that the race-based data does not necessarily result in initiatives are specifically pointed at Black communities. And the municipal government in Toronto is not, there's no initiative specifically for Black Canadians. The isolation centers aren't specifically for Black Canadians.
But you gave us an example of a very irrelevant one, education with respect to vaccines. Mm-hmm. While I understand that there's going to be education relevant to vaccines generally, you could appreciate that there would need to be a more targeted effort and focus on education of vaccines, specifically for Black Canadians, because there's a history, mostly in the United States, but that we're all very aware of in terms of how vaccinations of Black people have taken place over history. So that's a perfect example as to how the collection of race-based data would say, yeah, we're seeing Black people in a higher category of contracting COVID. They have higher risk factors for contracting COVID. They have higher risk factors for having a prolonged or worsened effects of the virus. And so it would be important and beneficial to those in that community that they get vaccinated. And so because we've collected this race-based data, we can have a very targeted attempt or rollout in terms of vaccination. You may have to spend more money in African Canadian communities in terms of vaccination education than you would in other communities, and collecting that data would assist you in doing that.
Well, we argue that the data isn't necessary for those initiatives that you point out. TAIBU, which was created before the pandemic, is working specifically with Black communities, not necessarily because of race-based data, but just because of their mandate to support Black communities as a whole, regardless of this type of information. And yes, we can see that vaccine trust in the Black community, as we've seen south of the border, is very important. And that is why TABU specifically is working to do that. But there's been no race-based data that told TABU to say, hey, let's create this initiative. It's just out of their own mandate as an organization. So I hope that answers your questions, Justice. But essentially what we're arguing is that race-based data is not necessary to mitigate these disparities, because the government pre-pandemic has been aware of some of these issues and is working to eradicate these problems.
So here's my problem with the position that you're taking, right? Is that while that works in large urban city centers, because you have these other organizations that are going to take the lead in providing that education, what happens in areas where you may have a Black population, Indigenous population, but it's not a large urban center? You don't have these kind of organizations that are going to provide this information with respect to vaccine rollout, right? You don't have a specific, African Canadian centric organization. So what happens in those parts of the country where you still are having these people who are still affected, and they could benefit from this type of targeted education and policy from the federal government, right? Because basically what you're saying is we don't have to. There's other places, and you've provided the GTA as an example, and that's great in large urban settings, but that might not be the same in Regina, Saskatchewan, right?
Right, and in those provinces, and I understand what you're saying in terms of the rural communities, but the federal government does have the media campaigns and the information that those communities in those areas are looking for. And I understand what you're saying in terms of perhaps more targeted information in these communities could be helpful. But we argue that this is we are telling all Canadians what to do to protect themselves from the virus. The virus doesn't discriminate. So we argue that.
No, but I thought we had moved past that. Your treatment does discriminate. It matters, right? It's not, it's education. It is an investment of resources in certain communities. That's what we're talking about. And we're not talking about social distancing, and we're not talking about how the virus affects people. We're talking about what we're doing to help people who are being disproportionately affected.
And just to your Justice James' point, what we're arguing is that the media campaigns that we are currently doing, for example, are providing those communities with the necessary information and how to protect themselves from the virus, understand that the vaccine is necessary to end the pandemic and it's safe. So all Canadians are getting this information. And yes, we can see perhaps in big cities like Toronto, maybe there are some more organizations that are more targeted to these communities. But at the same time, all Canadians are aware of this information, Black Canadians as well. So we argue that this targeted information is not necessary, because we've put the information out there, the statistics, the facts. Everyone is aware of the vaccine, the social distancing, etc. So I hope I
change topics just quickly, because at some point we're going to run out of time, and
Yeah.
This is a bit embarrassing, but I'm a criminal lawyer, and so I don't necessarily know the test for finding a Section 15 violation. So what is the legal framework that we're?
Yes. So as I mentioned earlier, in paragraphs 15 to 18 of our factum, it does outline the Section 15 test. So the first step is, does the law create a distinction on an enumerated or analogous ground? And that's currently the step I've been addressing for the last few minutes. And we argue that there is no distinction. And for the second step is, does the distinction create an arbitrary or discriminatory disadvantage, which I will just be getting into now if that's all right.
Yeah, yes, but when you do so, can you also help me with the question of how the Section 15 claim is related to the Section 7 claim? So if we are not with you and we find that there is a causal link between the government's decision not to collect this data and its disproportionate impact on racialized Canadians, and that is not consistent with the fundamental principles of justice. Does that also decide the Section 15 issue? Because then you would necessarily have discrimination.
Well, the Section 15 issue is we argue, is separate from our Section 7 argument. Just
Tests differ.
I'm sorry?
How would the test differ practically here?
Well, for the Section 15 test, it's focusing on the burden, the disadvantage to Black Canadians specifically, where the Section 7 test doesn't necessarily do that. So it is different in that regard.
But practically, that's the question that is relevant to both arguments, whether this decision is harmful to Black or racialized communities.
Yes, I guess, yes, that's
So
true.
is there any practical difference between the two arguments?
Well, there is practical difference between the two arguments because, especially in terms of is there a burden or denied benefit to the appellant? My colleague touched upon some of perhaps his argument, unfortunately, didn't get to touch on this, but there are some privacy issues that he was discussing in terms of collecting this data. Whereas for the Section 15 test, I'm focusing more on the discrimination, the racist rhetoric that may come from collecting this information. So it is slightly difficult, or different rather, in a practical sense.
Okay.
And Justice, I noticed that there is 5 minutes remaining in my time. Is it possible to get an extension on that?
So what we'll do is how we proceeded with the others. We'll allow you to continue, and then at the end of the 5 minutes, we'll determine kind of how much time you have left and what's needed.
Sure. So for our second step of the Section 15 test, we argue that the decision not to collect this race-based data does not impose a burden or deny a benefit to the appellant. And the reason we say that is when race-based data is used to explain the social determinants of health, it can inadvertently legitimize biological understandings of race. And this is an essentialist position that ties racial attributes and behaviors together. Racializing COVID could reinforce discriminatory notions that are connected to other forms of racial oppression, such as anti-immigration sentiments. And the minister took into account the historical and social disadvantages Black Canadians face in this country when deciding not to collect this data. And the minister did not want this data to inadvertently further marginalize this community. For example, if race-based data is routinely associated with medical conditions, doctors can inadvertently turn to race as illness-inducing. As a result, doctors may pay less attention to an individual's symptoms, patient history, or family history. And racial categories are wrongly assumed to be scientific despite their unscientific construction. Diseases like Tay-Sachs and sickle cell anemia have been described as the Jewish disease and the Black disease since the 1900s. And these associations with race can lead to inaccuracies in who is deemed high risk. And the minister does not want to see similar associations with a particular ethnic group or racial group and COVID-19.
So I'm going to ask a question there, because I do think that there's two distinctions, and you focused on one, which is the identification of race as the determinant of kind of the disease. So you're Black, you're more likely to have COVID than somebody who is Caucasian. That's one issue. But what about the determinative and having the race information in terms of the quality of treatment that is then received, right? So let's say I accept your argument, that may be an issue. But once we look at the race of the Caucasian and African Black Canadian, in terms of they've now both been tested positive for COVID, what is the difference in their health outcomes? How long does this person have COVID? What type of treatments are they able to access? What is the result? Is one person more likely to recover and the other person more likely to die? And so let's say we do accept the first part of your analysis, which is it could cause this issue with how we identify those when they first come in. in terms of saying, you're Black, you're more likely to have COVID. But what about the race-based data for the rest of it, right? Like, how do you address that?
Well, I would address that to address that question, Justice, I'll provide you with an example. There was a Black doctor in the U.S. Justice, I see that I have 1 minute remaining.
Don't worry, you keep going.
Okay,
We're monitoring the time. We'll make sure you
Okay.
have additional time. Yeah.
Okay, thank you. For an example, there was a Black doctor in the U.S. who had COVID, came into a hospital and outlined her symptoms. And because of racial bias in terms of Black people, the doctor treating her just assumed that she was making up her symptoms to get strong painkillers. So what we're saying is that if you racialize COVID, there could be an instance where you assume this person has COVID, but Black people in health outcomes have been discriminated against because of their race, and we just don't want to associate or racialize this disease. And because we've seen racist biases against Black people, we just don't want to further cause more biases with this information. And I hope that answers your question, Justice.
It does. You can go on.
Okay, thank you. I apologize, Justice, or Justices rather. Looks like I'm running a little bit out of time, so I hope you don't mind. I'm going to skip to our last theoretical argument that deference to the legislature is appropriate here.
Okay, and we're going to provide you an additional 5 minutes to make this.
5 minutes.
Yeah.
Thank you. The legislature and executive branch are better positioned than the courts to create policy. Deferring to elected officials' expertise is even more critical in times of emergency. The minister and other government officials use their institutional expertise to grapple with how they can preserve Canadians' health while not arbitrarily burdening certain groups. They are frequently weighing their options, so a deferential approach is appropriate here, considering there are so many ways to approach this issue and no certainty to which would be most effective. And further, the court should defer to elected officials when dealing with complex issues that require detailed knowledge of the socio-political context. As critical race theorists have outlined, discrimination is systemic and endemic, and racial hierarchies prevail in many government institutions, including healthcare. So the minister understands this and has sought help from experts to combat systemic racism. And with these right access to these resources, the minister came to the conclusion that the best course of action here is not to collect disaggregated race-based data. Additionally, courts are not always prepared to assume a proactive approach in redressing complex issues like institutional racism. In Mack versus Attorney General of Canada, the court held that it should defer to the legislature in situations of historic racial injustice. And the court recognized that it does not always have the requisite expertise to overturn these types of decisions. So again, we argue that deference is necessary for the aforementioned reasons. And to conclude my remarks today, I really want to emphasize this point. There is no playbook on how to handle a once-in-a-lifetime pandemic. There are no rules on how to protect people against a virus that we turn on the news is changing, becoming more difficult to identify and to treat. And the government concedes it has been challenging because as the science changes, as the experts make new recommendations, the government has to adapt and make quick decisions to fight this pandemic. And the unfortunate reality is that no matter what is done, lives will be lost, and we will forever mourn those Canadians. This pandemic has been challenging, but if you look at the facts and the statistics, Canada has been one of the best globally in terms of supporting its citizens through this crisis. Financially, with the CERB, ramping up production of PPE, paying manufacturers that don't usually make this equipment to change course and start making face masks and other protective gear, media campaigns on social distancing, the need to stay home, and now the vaccine, of course, which will be free for whoever wants it. We are working to end the pandemic, to make life easier for all Canadians, that's true. The Constitution that governs us stands for equality. This government stands for equality. But with that being said, this government does understand the unique challenges Black Canadians face, and especially now during this public health crisis. As I mentioned previously, there are organizations working to mitigate some of these racial disparities. We have hired experts to help us through this public health crisis, but of course, that is outside the scope of this litigation. And though we submit there is no constitutional issue here and the appeal should be dismissed, we promise to Mr. Williams and to all Black Canadians that the government is working day and night to keep you safe. And if there are no further questions, I will conclude my submissions this morning, or almost this afternoon. Thank you. I appreciate your time.
Thank you.
Thank you. So we have the appellants with, they would have the right of reply. And kind of given where our time is, we will provide you with 5 minutes for your reply. And I just remind you that this is good. The court always reminds you it's reply, not repeat. So we'd like you to focus on any kind of new issues that your friend has raised.
Thank you very much, Madam Justice. We appreciate the opportunity to respond. The appellant is aware that COVID-19 does not discriminate with respect to the assertion that the information we seek is relevant but not material. First to this, we would like to remind our friends that from Canada and CAP, we know that equal treatment does not equality make. And second, that in this statement, the respondents have actually conceded with the underlying premise of our claim, which they purport to disagree with. The collection of race-based data allows for the better understanding and creation of pandemic protocols which reflect the diverse needs of Canadians in an inclusive and equitable approach. How can this information not be both relevant and material? I wish to also remind our friends with respect to their assertions of positive obligations that this is exactly the situation which will permit such an imposition pursuant to the Living Tree Doctrine. Based on the case precedent that the respondents relied on, as a need is identified pursuant to the Living Tree Doctrine, as Chief Justice McLaughlin rooted her opinion on in Gosselin and Quebec, that where change is identified, change may be made. Where the necessary need for change is identified, change may be made, even so far as to create a positive obligation pursuant to a charter infringement. And this is according to McLaughlin. And lastly, to the point of deferring to the legislature, since at least the H1N1 crisis 10 years ago, the legislature has not made the necessary changes we seek today. We do not ask this honorable court to make or enforce law pursuant to the separation of powers, but what we ask is for them to fulfill their necessary role pursuant to the separation powers and adjudicate on only the matter before us today. The appellant wishes to leave this honorable court with this: the longer the minister fails to collect disaggregated race-based data, the longer pandemic protocols will continue to jeopardize the lives of racialized Canadians. And that is the bottom line. We thank this honorable court in allowing us to both submit and respond before you. And if there are no further questions, this concludes the submissions of the appellant. Thank you.
Thank you. Okay, Mr. Timer.
Yes, thank
So
you all
I-
for, pardon?
So go ahead.
Thank you all for attending the first round of the 2020 Julius Alexander Isaac Moot. When ready, I would like to invite the Honorable Justices Asha James and Michael Fawcett to dismiss the appellants and respondent teams back to the main room in order to begin deliberations.